Good day, ma'am. Today, I'm going to tackle about the 1987 Philippine Constitution, Article 3, Section 13, the right to bail. So before we delve deeper, let us first define bail. According to 114 Rules of Criminal Procedure, Section 1, bail defines a security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions hereinafter specified. Bail application does not only involve the right of the accused to temporary liberty but likewise of the state to protect the people and the peace of the community from dangerous elements. Bail exists because the law presumes that someone is innocent until proven guilty. Bail also exists to allow the accused to gather proof for his defense. The Constitution defines the Section 13 as all persons except those charged with offenses punishable by reclusion perpetua, when evidence of guilt is strong, shall, before conviction, be bailable by sufficient sureties or be released on recognizance as provided by the court. The right to bail shall not be impaired even when the privilege of habeas corpus is suspended. Excessive bail shall not be required. So the right to bail is actually a constitutional right. It is personal in nature and is therefore waivable, meaning the accused or someone can actually surrender or voluntarily give up your rights or privilege. So the right to bail springs from the presumption of innocence, which means every person or someone that is accused of any crime is considered innocent until proven guilty. That's why a person can file bail because there is a presumption of innocence nga ginahatag sa accused. So habang wala pa'y final judgment, the accused may post for a bail. So the application for bail must be in the custody of the law. If the bail is the security given for the release of person under custody, a bail cannot be availed of by someone outside the custody of law. Therefore, a free man is not entitled to bail because why would someone file bail if you're a free man naman, diba? So all kinds of bail are subject to the following conditions. First, the undertaking shall be effective upon approval and unless cancelled. Diri na involve ang RTC or the Regional Trial Court wherein the RTC has jurisdiction over the case. It's whether the case was originally filed in RTC or was just appealed to it. Second, accused shall appear before the proper court whenever required. So meaning, even if you are on bail, you should appear in court whenever you are required. C. The failure of the accused to appear in trial court without justification shall be deemed a waiver of his right to be present thereat. And lastly, letter D. The bondsman shall surrender the accused to the court for the execution of final judgment. Take note, a bondsman has the right to a warrantless arrest if you are jumping bail. In that case, the accused can be arrested without a warrant. It's also said that bail is a matter of right, but of course with exception. All persons in custody shall be admitted to bail as a matter of right, but of course with sufficient sureties and be released on recognizance as provided or as prescribed by the law. First, before or after conviction of the Metropolitan Trial Court, Municipal Trial Court in cities, province, and municipality, and Municipal Circuit Trial Court. On the other hand, it's before conviction by the Regional Trial Court of an offense not punishable by reclusion perpetua, death, or life imprisonment. So the bail becomes discretionary when the accused is already convicted by the Regional Trial Court, meaning accused already loses the presumption of innocence. No bail shall be allowed after the judgment of conviction has become final. The judgment become final 15 days after the promulgation if wala inhitabong appeal or motion for reconsideration. No bail shall be allowed after the accused has commenced to serve sentence. On the other hand, if accused is allowed to file for bail, then bail in the amount fixed may be filed with the court where the case is pending or any regional trial judge, municipal trial judge, metropolitan trial judge, municipal circuit trial judge in cities, province, or municipalities. So bail can be given in any form like corporate surety. So corporate surety is wherein any domestic or foreign corporation may provide bail by a bond subscribed jointly by the accused or an an officer of any corporation. The other one is property bond. It's a lien on the real property given as a security for the amount of bail. The other one is cash deposit. It is the accused or any person acting in his behalf may deposit a cash to the nearest collector, and the other one or the last one is recognizance. It allows the release of a person who cannot post bail due to inability to pay, and it's also governed by the RA 10389 or the Recognizance Act of 2012. The amount of bail should not be excessive, as I said earlier. A judge who issued the warrant or granted the application shall fix a reasonable amount of bail. First, the financial ability of the accused. Second, nature and circumstances of the offense. Third, penalty of the offense charge. Fourth, character and reputation of the accused. Fifth, age and health of the accused. Sixth, weight of the evidence against the accused. 7. Probability of the accused in hearing in trial court. 8. Forfeiture of other bail. And 9. The fact that the accused was fugitive from justice when arrested. And lastly, we have the pendency of other cases where the accused is on bail. So bail is not allowed to those persons charged with capital offense, reclusion perpetua, or life imprisonment, when evidence of guilt is strong, regardless of the stage of the criminal prosecution. Reclusion perpetua is a penalty handed down to inmates who have been convicted of capital offense, as well as what the Republic Act 7659 designates as heinous crimes. So example of these cases are treason, piracy, qualified trafficking, qualified bribery, parricide, murder, infanticide, kidnapping with illegal serious detention, rape, robbery with violence against or intimidation of persons, arson, and importation, distribution, manufacturing, and possession of illegal drugs, or the RA 9165, the Comprehensive Dangerous Drug Act of 2002. Also, kadtong mga cases nga under sa Republic Act 6036, bail shall not be required in cases of violations of municipal or city ordinances, like when the accused is a recidivist, quasi-recidivist, and a habitual delinquent, and mga cases wherein nag-commit of offenses ang accused while under parole or conditional pardon.